You're listening to David Bevan
on ABC Radio Adelaide.
Margaret Kaukas from Anderson Solicitors. Good morning. Margaret. Oh, Margaret, you're with us. Excellent. Margaret,
Sorry, yes.
Now, Margaret, you make a living out of industrial law here in South Australia. And
I do.
Every now and then, state governments have a go at changing industrial law. I can remember Graham Ingerson having a go back in the early 90s, and there were all sorts of protests and fights over it. And then, most recently, Jack Snelling in the Weatherall government, he had a go at it, and now I'm pretty sure it was Jack, and now Rob Lucas is having a go. What do you say these latest changes are, and why are you worried?
I think most people who act for injured workers are appalled by these latest changes. I'll just give a bit of context for your listeners, David. Before 2014, South Australia had probably the best and most generous workers' compensation scheme in the country. In 2014, the scheme was amended, presumably we understand because work cover was in the red, and previously injured workers who couldn't return to their earning capacity were entitled to have income support for the rest of their working life. In 2014, that was reduced to a maximum for most workers of 2 years. So for most workers today, after 2 years, if you're still carrying an injury and you haven't been able to return to work, well, sorry, mate, you're on Centrelink. Medical expenses are covered for 3 years, except for a class of workers who are called seriously injured workers. Now, in addition to those entitlements, an injured worker also has an entitlement to 2 lump sum payments for permanent impairment. And the rules are that if they're assessed by an accredited doctor and they're assessed as having a permanent impairment of at least 5% loss of use of their whole body, they are entitled to a lump sum. Now, those assessments can only be done by an accredited doctor, which currently the worker can choose, and the assessments have to be conducted pursuant to certain guidelines called the Impairment Assessment Guidelines. What the government is currently proposing to do is to amend those guidelines. Now, guidelines are what we call subordinate legislation, and we believe that what the government is trying to do by amending these guidelines, they don't have to go before Parliament. Return to Work, we understand, drafted the guidelines. The Minister signs off on them, and so there's been no scrutiny of Parliament by these in relation to these changes. And we believe, that is, lawyers who act for injured workers, believe that this is a sneaky way of cutting compensation to injured workers, because we truly believe that the end result of these amendments will be less workers will qualify for the lump sum payments, and workers who do qualify for the lump sum payments will get less. Now, I'm happy to speak to how that has occurred in more detail if you like, although it may be a bit too technical. But I will say this, David. There was a group of doctors. Well, firstly, the proposed changes were issued with a 4-week consultation period, 4 weeks only. There's 72 proposed changes, and that consultation paper wasn't sent to many law bodies like the Australian Lawyers Association.
Well, no, you wouldn't want them to know.
No, of course. And in fact, the Australian Lawyers Association had only found out about it in mid-June. So they had less than 2 weeks to comment on 72 changes. But one of the groups that did comment on it was a group of doctors who have been providing assessments in South Australia for 15 years, whose assessments have been tested by courts, who are very experienced. And they said this. They said, Return to Work reckons this is going to result in a fairer outcome. Return to Work says that this won't affect most injured workers. Their assessments will be the same. There'll be a small number of workers who'll get a bit less. There'll be a small number of workers who'll get a bit more. Now, these doctors say all of that is incorrect. And in fact, they conducted an analysis based on actual injured workers who've been assessed in the past. And if you bear with me, I'll take you through some of those analyses. So
I think we get the gist of it. So
yeah, sure.
Let's go to Rob Lucas, who's the Treasurer and who has carriage of industrial issues. Good morning, Rob Lucas.
Good morning.
Well, is Margaret Kaukas right?
Well, no, because it's not a sneaky way of doing it. This was actually in the pre-existing legislation. It was actually in the legislation that John Rao brought to the Parliament, and the Parliament actually endorsed, and that is that the Minister responsible for the legislation had the power to amend these particular impairment assessment guidelines based on advice and consultation under the terms of the legislation. So the Parliament voted for this, the Labor government did it. There was no criticism from law representatives or legal representatives when the Labor government amended these guidelines back in 2015. The process that I'm using is consistent with the Act and exactly consistent with the way the Labor government did it back in 2015.
Well, I don't think Margaret Kaukas is saying that what you're doing is illegal. She's just saying that...
she's saying it's sneaky.
No, but you can do it, but it's sneaky. I mean, it's legal for you to be sneaky because you can change... you have the power under the Act to change the guidelines, which she says will reduce the amount of money injured workers will get.
Sure. Now, but I didn't hear the same criticism of John Rao in 2015.
Well, maybe because he didn't do anything sneaky. He might have had the power, but he wasn't sneaky with it.
Well, he had the same power and he used it, and I've got the same power evidently. And I guess the bottom line in relation to all of this is I've not made any decision yet. A Return to Work SA has gone out to consultation. I, in fact, met with Nick Xenophon only last Thursday or Friday to listen to his concerns about aspects of the legislation. Return to Work SA's recommendations to me have not yet been approved. I have to make the final decision under the terms of the legislation. I've also extended the consultation for the Ministerial Advisory Committee by another month to the end of this month because that body is independent. It has 3 medical representatives on it. It has 3 union representatives, 2 of whom are lawyers who work in the jurisdiction, and there are 3 employer representatives, and they'll provide me with their advice at the end of this particular month before I make my decision.
Okay. Do you agree with Margaret Kaukas's broad basic point, and that is that under the changes that you have flagged, workers will be worse off?
Well, no, because in the end, I've not made any decisions yet, David. So
no. I appreciate you haven't made it, but you have flagged some changes, and I'm just saying
Return to Work SA have gone out to consultation. They're recommending to me as the responsible minister. They're consulting, and I'll listen to their recommendations and the consultation and advice that I get.
All right. Well, here's the question. Do you agree with Margaret's broad point that under these changes proposed by Return to Work, workers will be worse off?
No, the advice I've been given is it'll impact some workers in different ways, but certainly Return to Work SA's advice to me has been, and that is obviously being challenged by Margaret and others, but Return to Work SA's advice to me is that this is a fair package overall in terms of both the treatment of injured workers, but also in relation to the scheme. The scheme requirements are, under the legislation from John Rao and the Labor government, which we supported, was that essentially we not have to try as a goal or objective to keep premium rates for employers in South Australia below 2%. And if you actually go above 2%, you're required to go back to Parliament and indicate why that might be the case. The scheme is under pressure. Return to Work SA has advised there are a number of elements in terms of both improving the quality of services that are being provided, but also in terms of the health of the scheme, which have to be considered by me as the responsible minister. I've not made a decision yet. I'll listen to the advice of Margaret and others, and then I have to make a final decision under the terms of the legislation.
And when will you make that final decision?
Well, it'll be after I certainly receive the Ministerial Advisory Committee recommendations at the end of the month. So at some time after that, I'll make the decision in relation
sometime in August.
Well, it'll be sometime after I receive the advice at the end of July. So it won't be long after that because I've been meeting with people like Nick Xenophon and others who are putting a view different to Return to Work SA.
Is this like, put it in context for us, Rob Lucas, is this, are we considering deficits like the ones that Graham Ingerson was battling back in the 90s and that you remember the huge changes he made to workers' compensation back then, and there were massive rallies out the front of Parliament House. Is that the sort of thing we're looking at here?
Well, frankly, I think the changes the Labor government, John Rao, made in 2015 were much more significant in terms of the impact on injured workers and the scheme than the Graham Ingerson changes in the 1990s. I'll concede to you that the protests in the 1990s were much bigger because it was a Liberal government that was initiating the changes, but the changes and the change of the impact under John Rao and the Labor government, which we supported, were nowhere near as significant as the opposition to the Graham Ingerson initiated changes of the former Liberal government.
All right. Well, you haven't made a final decision.
No.
There are concerns both amongst doctors and lawyers who deal in this area. You're taking advice. You'll make a decision sometime in the next few
Soon
weeks.
after the end of July, yes.
All right. Well, Rob Lucas, thank you very much for talking to us.
Thank you, David Bevan.
Rob Lucas, Treasurer here in South Australia, responsible for industrial matters under Stephen Marshall's government. And before that, Margaret Kaukas, Special Counsel in Workplace at Anderson Solicitors. Margaret's been one of our regular lawyers who's come in and given us advice.